Contracting and privatization. Business and public administration are alike only in all unimportant respects. Wallace Sayer. The privatization movement is here to stay. While different people may define privatization in different ways, there seems to be a general agreement that government needs to shrink in favor of an increased role for the private sector. One is the influence of public choice theory. This is the common sense belief that the private sector can perform government functions more efficiently and effectively than the public sector. In his 1987 article published in the Public Administration Review, a top journal in the field of public administration, Ronald Moe uses a public law frame to explore the limits of privatization. In doing so, he presents one of the most compelling arguments for the distinctiveness of the public sector. He argues that while the functions of both sectors are complex and ambiguous, there must be a line which separates that which is public or governmental and that which is private. Public law tradition. Privatization has its intellectual roots in free market economic theory, and its promoters have a worldview that admits few limitations. Public administration as a field of study not sharing the perspective of the free market economists first ignored, then resisted the privatization challenge. To understand the potential of privatization, it is first necessary to understand its limitations. Once simply a group of scholars, the privatization movement has come of age. It is held together by a shared belief that the public sector is too large and that many functions presently performed by government might be better assigned to private sector units, directly or indirectly left to the play of the marketplace. The private sector, it is argued, will perform these functions more efficiently and economically than the public sector. Implicit in the rhetoric of the privatization movement is the view that the public and private sectors are alike, both subject to the same set of economic incentives and disincentives, that many functions are interchangeable. The key question is which sector performs functions more efficiently and economically. Problems that arise in connections with legal status or organizational structure are considered of secondary interest and importance. Implicit in the dialogue of the privatization movement is the view that public and private sectors are subject to the same economic incentives and hence function in similar ways. There are two prevailing schools of thought on this matter. Professor Barry Bozeman's book titled All Organizations Are Public posits that public and private organizations are alike in all of the essentials and differ only with respect to the non-essentials. If this is the case, then one could argue that many functions of both sectors are interchangeable, that all public sector activities can be delivered by the private sector. William Sayer, of course, takes the opposite view of Bozeman. He argues that the public and private sectors are alike in the non-essentials, but it is in the essentials where they differ, and that these distinctions should not be taken lightly. Moe argues that a line must separate that which is public or governmental and that which is private. He argues that the fundamental basis of this line is to be found in public law, not in economic or behavioral theories. In the U.S., the Constitution, statute law, and the political culture all tend to promote and reinforce the separate and distinct basis for the public, governmental, and private sectors. While separation is encouraged, this has not discouraged cooperation between the sectors. This cooperation has rarely involved joint ownership ventures at the national level of government. The case of the Second Bank of the United States. The Second Bank of the U.S. was chartered by an act of Congress in 1816 for a 20-year period. The state of Maryland attempted to tax the operations of the Baltimore branch of the bank, a decision challenged in the courts. The U.S. Supreme Court, in the case of McCulloch versus Maryland in 1819, attempted to define the status of this bank. The ruling of the court provided an important lesson. The power to tax is the power to destroy. What we learned from this Supreme Court case is that a sovereign cannot be taxed by a subordinate unit, since to do so would permit another body to determine the fate of the sovereign. Beyond the taxation issue, the court considered the bank to be an instrumentality of the sovereign, or an agency of the United States. The Chartering Act required that 20% of the stock be owned by the federal government, while 80% was to be held in private hands. It was subsequently assumed that if the federal government owned any portion of a corporate body, the entire body acquired the attributes of the sovereign. The legal questions in this case were secondary to the political ones. Andrew Jackson became an enemy and was successful in dismantling this bank. He was concerned that private owners were enjoying the benefits of its favored legal status. Jackson waged a war on the bank on the grounds that it violated the American political culture. He won that war. And for the remainder of the 19th century, the federal government did not own stock in any corporation. When it wanted a public function performed, it provided the function through a regular government agency or by contract with a provider. The lesson here is there are limits, both constitutional and political, to privatization ventures. The privatization movement has forced political and academic leaders to reopen questions long considered settled. The assignment of functions is one such area where the settled had again become unsettled. The assignment was to be handled on pragmatic political grounds. It didn't matter much if the federal government owned and operated some facility. It would be equally managed as any private firm. This comfortable assumption was challenged by arguing in empirical economic terms that most facilities could be run more economically by the private sector and therefore ought to be assigned to the private sector. This challenge by free market economists highlighted the hidden reality that public administrators had seldom developed sophisticated or comprehensive criteria to assist lawmakers in deciding where to best assign a public function. In the American political and cultural setting, the public and private sectors are fundamentally different and ultimately distinctive in character. Sovereignty is the single most important characteristic that separates the public and private sectors. The concept of sovereignty is such that the federal government possesses the rights and immunities of the sovereign. Organizations in the private sector do not or ought not possess such rights and immunities. What are the attributes of the sovereign? First, the sovereign possesses the legitimate right to use coercion to enforce its will. The sovereign can coerce organizations, groups, and individuals to conform to the laws it makes. The sovereign may, for instance, tax citizens and corporations and impose penalties on those who resist paying taxes. Second, only a sovereign may legitimately go to war with another sovereign. Third, sovereigns can do no wrong. If a sovereign is to be preeminent over all others within a territorial jurisdiction, it cannot be subject to the constraints or injuries except by its permission. Thus, sovereigns are immune from suit except by their permission. Fourth, a sovereign is indivisible. It cannot assign its attributes to a private party and remain sovereign. A sovereign cannot share its powers with another body claiming sovereignty. The American Civil War was fought over conflicting theories of sovereignty. Lincoln argued for the concept of individual sovereignty, while the Southern states argued for a system of dual sovereignty. Fifth, a sovereign may disavow debts but cannot go bankrupt. More on the attributes of the sovereign. One of the tests applied to determine whether or not an organization is part of the federal government is the test of whether or not its obligations are backed by the full faith and credit of the Treasury. The right to declare bankruptcy, that is, to be cleared by law of financial obligation, is a personal or private right not inherent to the sovereign. Sixth, the sovereign has the right to establish the rules for protection and transference of property, both public and private. The sovereign has the right to take private property through eminent domain to promote a public purpose. And finally, sovereigns must provide the means of contract enforcement and other safeguards for the transaction of business. How should public functions be assigned? Should economic questions trump legal ones? Does the performance of the function necessarily involve the powers properly reserved to the sovereign? Or is the function largely private in character, requiring none of the coercive powers of the sovereign? Questions concerning the relative economic costs for providing the service appear to be secondary, or at least subsequent to the resolution of the more fundamental legal issues. In his work, Ronald Moe concludes that the best thing that can happen to the private sector is a first-class public sector. Why does he say this? The privatization movement deserves a great deal of credit for reigniting the debate over basic issues worldwide. Public choice theory and its free market concepts present an elegant and persuasive argument in favor of privatization over nationalization. We need a better theory of government that is capable of providing the legal, economic, and public justification for a first-class public sector.